Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, we're gonna get things started here. I had this one closed off, and so we're gonna go ahead and shut this down. We're gonna play some music in just a moment because I need my music. Y'all knows this. Give me 1 second. Where's the music at? Let's, yeah, we already listened to Mother. Anyway, we already listened to what's going on. But why don't we go ahead and listen to Marvin talk a little bit more about what's going on, y'all? Because we should be able to hear that. I can't hear Marvin, y'all. What's going on? Did you hear? Oh, now he's gonna sing Inner City Blues, so he ain't doing what's going on. Okay, but I like this song too, y'all. All right, ladies and gentlemen, ladies and gents. As I told y'all, I had to go through all of my stuff. All of my stuff. Let's close that one. Assignments. Okay. These are all of my folders, PDFs that I have on my computer. And what I had to do is I had to locate the assignment that we had done last year to see if the arbitration agreement included all the things Supreme Court said are necessary, only to find out it did, but it did not include one extra thing that we were going to be adding, so I'm going to add it to the sample one because we have some time. So let's go ahead and go over this notice of assignment because it makes me want to holla, you know. Holla! Anyway, the assignment of equitable rights and interests. This assignment dated this day, January 10th, 2014. We're gonna change that to 2019 because this is an updated thing. Um, oh wait! I ain't gotta do all that January thing. Okay, 0, 0. Uh-oh, 2019. Okay, get out of here. Don't need y'all. And then, uh-oh, did that backwards, y'all. This is 14, and this is, hold on, 2019. Replace all. Yeah, and there's about 4 sections that it's in, but it makes me want to holla, y'all. Makes me want to holla, holla, holla. All right, let's go ahead and go over the document so that you guys will know. Now, this is about the redemption, equitable right of redemption, and you have to do what's called a notice of assignment. And so we took and gotten rid of all the names of all the other parties. Okay? Notification of assignment, assignment of equitable rights and interests. This assignment dated January 10, 2019, between Helen Secchi, the grantor of the Helen Secchi estate, assigner. The estate is assigning the property because the property is held in a state. Thought you guys knew that. Well, if you didn't know, you know. Of Jefferson County, California. I don't know where Jefferson County, California is. I don't even know if it exists. I just created it. And then Walter Jemerson. He's Helena's cousin that she trusts. She been knowing him for years. And he rich. So he don't need her money, don't need her house. And she trusts him. That's the point. She know he ain't going to try to get over on him. Plus, they have a side contract to where if he does try to get over on him, he gives up pretty much all of his properties. And he's a millionaire. And so, you know, man. Okay. Give me 1 second because I have to holla. Cleaning my glasses, y'all. Alright. Because I had some specks on my spectacles. And I had to clean off them specks that were on my spectacles because it was interfering with my speculating. Alright, let's get on to it. Whereas, by an assignment of equitable rights and interests dated January 10th, 2019, equitable rights and interests, and recorded in the county of Clarksdale, because, now this, we didn't record. We recorded it, but we didn't record it in the county, okay? That's the other part that we're supposed to put up here. That's why I was slowing down. Hold on, y'all. I'm gonna have to go back to my PDF folder. Let me see. I gotta go back to my PDF folder. Y'all gotta give me a second, okay? Y'all just gonna have to hold up because I'm doing too much here. That's what I was supposed to be doing. I apologize, y'all. I've been listening to Al Green, but this is notification of assignment. We're gonna get back to the assignment. What we did was we added that right there. That's all we did because that was supposed to be there. I was supposed to do that for you guys. We didn't have that on ours, so I was supposed to do that for you guys. That's why we didn't record it, because we just needed to give notice to the assigner and assignee. You'll see why we did ours the way we did. So I want you to pay attention. By assignment of the executable rights, as we just talked about, we have the property, the physical address, and or land property account loan number, and so we give them the account number and the physical address. Okay, I hereby assign the associated equitable rights and interests in favor of the assignee for the principal sum of $10, to include the rights of redemption therein set out upon the terms therein mentioned, therein, herein, that type of thing. There is now owing upon equitable rights and interests for principal together with the interest thereon from the date of, you will enter the date here, which is January. No, we're going to just give y'all that right there. Okay, the assigner has agreed to assign equitable rights and interests to the assignee. In consideration of the premises and for goods and valuable consideration, and the receipt and sufficiency of which is hereby acknowledged, the parties hereby agree as follows. The assigner agrees to assign and transfer set over to the assignee assigner's interests as equitable rights and interest holder of and in equitable rights and interests, and also the sum amounts of indebtedness now owing from equitable rights and interests, together with all monies that may hereafter become due or owing in respects to equitable rights and interests, the charge upon the property, and the full benefits of all powers and covenants contained in the equitable rights and interests, and also the full power and authority to use the name and or names of the assignor for enforcing the performance of the covenants and other matters and things contained in equitable rights and interests associated with the property and or the assets associated and or attached to the property. The assigner makes this assignment to the assignee to have and to hold the said equitable rights and interests and all monies arising in respects to the same, and to accrue thereon to the use of the assignee absolutely as they deem necessary and subject to the terms and conditions of such equitable rights and interests. Whew. It's only 4 pages, y'all, so let's continue. The assigner hereby covenants with the assignee the equitable rights and interests is a good and valid security, and the sum amount of indebtedness now owing from equitable rights and interests the borrower to the assigner, and that the assigner has not done or permitted any act, matter, or thing whereby the equitable rights and interests have been released and or discharged, either partly and or entirely, to the best of the assigner's knowledge. And furthermore, if such has been done, this contract supersedes any other agreement to the contrary of its contents, terms, and conditions of this agreement, to the exception of an exclusive agreement that so specifies its exclusivity. Man, but doesn't a deed of trust so specify its exclusivity? That's right, but here's the thing. An assignment supersedes a deed of trust, because she's assigning her equitable rights. So the deed of trust does not secure your equitable rights. The assignee may collect, realize, sell, or otherwise deal with the assigned account and or any part thereof in such manner, upon such terms and conditions, and at such time and or times as may seem to it advisable, and without notice to the assigner, except as otherwise required by any prior agreement and or applicable law, and may charge on its own behalf, and pay other reasonable sums for expenses incurred and for the services rendered expressly, including legal advice and services, as well as payment in accord with the Gold Repeal Act, Title 12 USC, Act, Title 12 USC 411, and Presidential Proclamation 2039, in or in connection with collection, realizing, selling, or obtaining payment for the assigned accounts, and may add to the amounts of such sums of the indebtedness of the estate of the assigner, but only through the United States Treasury Department and or custodian of record of such estate. It's supposed to be estate. That's voice recognition, y'all. Okay, that's voice recognition. The parties of this agreement hereby agree and settle any and all matters, disputes, disagreements, issues, whether directly or related and or indirectly related to the matter associated hereto this agreement, herein through arbitration, and the arbitrator shall have exclusive jurisdiction over the matter, controversies, disagreements, issues, disputes directly and or indirectly associated with the instant matter, and the parties agree that arbitration shall be the sole remedy for any dispute arising herefrom, hereto, herein, related hereto, herein, hereof. Whew. Now I gotta pause y'all one more time. Okay, ladies and gentlemen, there was some issues that I had to go take care of. The parties of this agreement hereby agree to settle any and all matters, disputes, disagreements, issues, whether directly related and or indirectly related to the matters associated hereto this agreement, herein through arbitration. The arbitrator shall have exclusive jurisdiction over the matters, controversies, disagreements, issues, disputes directly and or indirectly associated with this instant matter, and the parties agree that the arbitrator shall be the sole remedy. Arbitration shall be the sole remedy for any disputes arising herefrom, hereto, herein. That's what we gotta correct. Okay, just had to, like I said, it just gotta be. All right. That's what happens when you copy and paste. Special notification in line with the agreement. The Federal Arbitration Act is relevant here. The Act provides that a written provision in a contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract shall be valid, irrevocable, enforceable, saved upon the grounds that exist in law or in equity for the revocation of any contract. That's why our contract is done in equity. But 9 USC, pay attention that if a controversy arises and it says it involves commerce, it shall be by arbitration if there's an arbitration agreement. That is what the law says. It says it shall be valid, irrevocable, and enforceable in any court. That's why the Supreme Court had no choice, because they decided to bring that matter before it. Under the Act, arbitration is a matter of contract, and the courts must enforce arbitration contracts according to the terms of the arbitration contract. Rent a center. The parties may agree to have an arbitrator decide not only the merits of a particular dispute, but also the gateway questions of arbitrability, such as whether or not their agreement covers a particular controversy. That's for the arbitrator to decide. Under the Federal Arbitration Act, parties to a contract may agree that an arbitrator rather than a court will resolve disputes arising out of the contract. When a dispute arises, the parties sometimes may disagree not only about the merits of the dispute, but also about the threshold arbitrability question, that is, whether their arbitration agreement applies to a particular dispute. Who decides that threshold arbitrability question? Under the Act, and this court's cases, the Supreme Court, the question of who decides arbitrability is itself a question of contract. The Act allows parties to agree by contract to an arbitrator rather than a court will resolve the threshold question, okay, of arbitrability, as well as the underlying merits of the dispute. Already decided. This agreement establishes and creates a special relationship whereby the arbitrator shall be assigned as trustee and may act only within the framework of this agreement, irrespective of statutes, regulation, code, ordinances, and must adhere to the Federal Arbitration Act so long as it is consistent with the terms and conditions specified herein and throughout. Helen Sechi, an infant, as defined in statute, an estate having value, I hereby assign all equitable interests and rights over said estate to the assignee. Ladies and gentlemen, your infant estate, you can assign the interest in that estate to someone else, and they, pay attention, can do exactly what Mr. Pay Attention Chess did. Now, I'm not going to go over it again. You guys are going to have to go over the chess video yourselves. Okay? Give me a second. Somebody was saying, hey guys, we went to your site and they were talking about the SAA site, and they say, hey, we went to your site and we clicked on this and it pulled up nothing because we're migrating the site over, and so we did correct the links, so the links do work. When I say we don't have anything to do with SAA. The only thing we do is logistics. We handle the back end, we handle the website and all that technical stuff. They don't have to worry about that at all. So they just call us, we take care of it. All right, let's do this so that you guys will understand. Yeah, because I don't have it up. CHESSV Burt, B-U-R-T. Where's Ernie, Burt? Boo-boo, how's about a picnic basket? Mr. Ranger, sir. Here is the Chess versus Burt. Okay? Atlanta Court of Civil Appeals. Chess versus Burt. You guys are going to want to read this case. I'm tired of going over it for y'all. Y'all need to read it and understand it, because guess what? Executed a document titled Assignment of Statutory Right of Redemption from Foreclosure. Now hers was specific. Our document is just labeled Right of Redemption in the document, but it is an assignment. That's all it needs to be, is an assignment. Okay, now let's finish this. Oh, got to stretch. So that's the case you want to pay attention to. As I said in the last video, somebody wrote me from Australia, and the Australia person was saying, I tried using the California law and the New Hampshire law, and I didn't have a license, and they stopped me and they pulled me over, and so now they held me in jail for a day, and they're trying to take my husband's car. Well, look, here's the thing. Let me make sure y'all understand. Ain't nobody ever told y'all to use California law in New Hampshire and New Hampshire law in California, or vice versa, or any other. Simply put, nobody ever told y'all that the law is binding. We said the principles of law. Australia has its own laws, but it's still under the same administrative system. So what you have to do is you have to find the laws in your state which require only those who operate commercial vehicles to have driver's licenses. California and the United States, there is no commercial driver's license for the private citizen. It's called private citizen rights. Well, the same as this right here. Ladies and gentlemen, you have to do your research. You just can't take a document and just use it. Now, the contracts, like we had one person said, look, there were some things in a contract that I didn't fill out correctly and I need to complete. Excuse me? There are some things in a contract that I didn't fill out correctly I need to complete. Okay, then why did you send it to us without completing it? Well, I just need to know if I can get it back. You can't talk to me about that. I don't run that organization. You see what I'm saying? All right, so we're going to finish. These are only templates, people. All right, but redemption value of the estate through arbitration, and that the arbitrator as well as the arbitration award shall be binding on all parties and shall not be the subject of review unless there is found that the arbitrator acted outside the scope of this agreement or did not exercise reasonable judgment within the framework of this agreement, or has committed fraud with respect to this agreement, and or has failed to render a determination equating to 2 times the value claimed by either party against the opposing party found in default. Okay, so by the party against the party found in default is what it's saying. It shall further be had that any party, whether that party be a party of interest or a non-party, are non-interested party or a third party or a custodian or a trustee or an official of a corporation or a collective entity or a trust or government and or any other organization having a disagreement, claim and or a complainant complaint, excuse me, an issue, a controversy, a dispute respecting any of the properties, matters, issues, interests, equitable or otherwise, in reference to this agreement and or the aforementioned shall be bound by the terms of this agreement and must recognize as well as utilize the sole remedy of arbitration. Basically, anybody who wants to even have anything associated with the equitable rights or a dispute over whether or not you have equitable rights. Now, what's equitable rights? Well, when they put a lien on your property, like the deed of trust, and they come and they foreclose on your property, what you maintain is the equity in the property. They don't have a right to that because you'd never signed that over to them. You're now assigning that to someone else. They have the right to pay off the property. But as I told everybody, when the banks pay for your property, when they give you that loan, they do it with credit. They do not do it with cash. Okay, now some of you guys need to pay attention. Some of you do receive a cash loan, but that's when you take out a cash loan and they literally give you the cash. But now you need to go through the records and prove they didn't give you cash, they gave you credit. That's another battle. Don't come to me about that. That ain't my job. That's your job to do your research and your job to prove your point. I'm not here to answer all your questions. Now, many of you guys, the problem that many of you are doing, you're going to SATCOM and you're going to SAA and you're talking to them about the stuff I talked to you about on video. You can't do that. This stuff ain't got nothing to do with those two organizations. They ain't got nothing to do with this. They just provide services for other stuff. But they don't talk about all this stuff, so please stop that. Okay, notice and request. At any time, if any interested party has expenses and expenditures associated with the aforementioned property, that upon notification and or receipt of this communication, you shall have 10 calendar days in which to supply such information and or notification. Failure to supply that information within 10 calendar day period will constitute estoppel, whereby that party, the party failing to supply the information within the specified time period allowed, will have waived any and all right to complain and or bring forth a complaint, a claim, a charge, a fault. This agreement shall be binding on all parties and shall be irrevocable as well as self-executing upon receipt. Any party defaulting on their obligation shall be liable for up to 3 times the value of the agreement, contract, or got to change this. That was in the original. And it's got to be 3 times the original value. So the original was $12 million. So we do $3 million. So 3 times the original value or $3 million, whichever is greater, shall constitute liability and acquiescence and agreement. Okay? So why didn't it's supposed to have copied correctly? I gotta find my mouse. Sorry, my mouse is all over the place. So there it is. I found it. Okay. Any interested party and or third party and or non-directly related party shall be held in special relationship of this trust agreement, and their introduction into this matter shall constitute their assuming the role of trustee and carrying out the dictates of this agreement, including all terms and conditions, with the exception of arbitrator. As the parties hereby and herein agree that the arbitrator shall have the exclusive jurisdiction to determine the validity of the agreement, as well as the validity of the arbitration clause, as well as the venue for arbitration, should there be one, and that the parties agree that the assignee mentioned above shall have the sole right of choosing an independent arbitrator. The assignee, the arbitration association, at which time the arbitration association shall pick an arbitrator at random who is not a member of the bar to act as arbitrator. We were recognizing that most arbitrators were members of the bar. We didn't have proof of that until just recently, but we now know that most arbitrators are members of the bar. We don't want no members of the bar. Any disagreement by any party concerning the arbitration clause shall be had before an arbitrator who, as specified herein and above, and all parties are bound by the dictates, terms, conditions, and of this conditional acceptance and offer. because that's what this is. We're accepting whatever they claim they are owed, and we're giving them the change in terms. Okay. The assigner shall, from time to time, forthwith, on assignee's request, do, make, and execute all such further assignments, documents, acts, matters, and things as may be required by assignee, of or with respect to equitable rights and interests, as may be required to give effect of these presents, including but not limited to obtaining waivers and subordinations of interests of equitable rights and interests from any person having prior claim or interest hereto, and only upon proof of claim that has been documented and verified as valid. Assigner hereby constitutes and appoints assignee the true and lawful attorney of assignor, irrevocable, with full power and or substitution to do, make, and execute all such statements, assignments, documents, acts, matters, or things with the right to use the name of the assigner whenever and wherever it may be deemed necessary and expedient. That's why you need a person you can trust. Somebody you can trust, not somebody you think you can trust. Lord have mercy, because I don't want to hear it. You sitting up there just getting anybody. The provisions hereof shall inure to the benefit of the successors and assigns of the assignee, and shall be binding upon the respective heirs, executors, administrators, successors, and assigns of assignor. This is the entirety of the agreement. Any changes must be made in writing and signed by both parties. Any disputes must be brought in the form of arbitration as agreed upon by the arbitration clause of this agreement. Do you understand? Everybody, this is your notice of assignment. If you truly want to know why this document is necessary, because not all of you spend the time to watch my video, some of you only watch the first 15 minutes thinking that's where you're going to get all the information from, and you are the, let me see, I got to be nice, you're the most intelligent people of the group. And so for you individuals who are so privileged and intelligent, thinking that I'm going to give you all the meat of the information at the beginning of the video, yeah, you keep thinking. All right, this is the case you need to go check out. Stephen Chess versus Wade Burt. Dwayne Wade? No, Wade Burt. Dwayne? No, anyway, decided December 11th, and it's in Alabama. Alabama. You know, Bama. Y'all know Bama? Man, Bama, me and Bama got along just fine. Oh, y'all don't know who Bama was? Bama was somebody I went to school with. He was from Alabama, and we called him Bama. The same as most other people in other states call somebody from Alabama. They just call them Bama because they don't want to say their name, you know. Okay. Let's see. There is just so much to talk about. I'm going to end this video. I want to talk about that young man, Jesse. I could care less about Jesse. I didn't even know who that fool was until all this junk was being talked about and him doing interviews on ABC. I didn't care about the man. However, I do know that something ain't right. So I want to give you guys the story, and I want you all, I only deal with logic, people. I want you guys to go and listen. At the very beginning, when he said someone assaulted him, the police said they didn't believe him. Now I want you to pay attention to this. Don't worry about the rest of the story. Stay with this story. Forget everything you were told. Okay, the first thing the police said is they did not believe him. That was their very first words. And then in their investigation, they found two guys who were potential suspects. And they talked to them, and they said it was likely that these are the suspects and that they were going to proceed with prosecution. Then the next thing you know, these two suspects claimed that they were paid. Well, where did they get that idea from? Because if they claim they were paid, how come nobody, and you know that they've done this, how come nobody's checked Jesse's bank account to see if $7,000 has been deducted from that account? Because they said they paid him $3,500 a piece. So that's $7,000 for a add-in actor. In other words, he doesn't play a main role. He plays a secondary role on the show, so that means he ain't got $7,000 to be spending out of his pocket anytime he feel like it. There's going to be a paper trail. So where is the money? You notice they haven't mentioned it. Now they'll claim that there was $7,000. No, it has to be $3,500 plus $3,500, or a total of $7,000. It cannot be $2,500 and then $20, and then $20 more, and then $20 more until he makes payments. No, 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 no. They said he gave him $3,500, and that was what the police. Do you notice how the police kept leaking stories on Twitter? The police kept leaking stories on Twitter. Why are the police departments using Twitter to communicate about a case? Revealing evidence to people on Twitter. That's not how it's supposed to be, people. And then we got two cases being held, two primal cases that is taken the total news being held in the same county in the same state. Can anybody tell me anything about revenue? Yep, a lot of revenue coming into that state, and both of these things happening at the same time. Two high profile cases in the same state, in the same court, by the same district attorney. Can anybody say revenue stream? So something ain't right. Now, Jesse, did he lie? I don't know. But I tell you what, something ain't right, because the police are lying. Because they said they didn't believe him at first. Ladies and gentlemen, if the police didn't believe him at first, they're not supposed to be telling that to the media. They're supposed to be doing an investigation and saying, well, we didn't find any validity, blah, blah, blah. That's what they're supposed to be doing, but they didn't do that. And they say the cameras didn't catch the assault. Well, excuse me, then how can you prove he wasn't assaulted? Interesting. Oh, by the way, ladies and gentlemen, they wanted his phone records. And they got upset because he wouldn't give them his phone records. Ladies and gentlemen, the reason why he didn't give them the phone records is because that means they get to go through the whole phone and collect all kind of information on a man, collect all kind of other stuff that is on his phone. That's a violation of his due process rights, and he said no, and he has a right to say no. Now, if they had a search warrant and they were only looking for that bit of information, then by all means, because they said they wanted to check his phone records because they said he was on the phone at the time of the incident, and his manager said he was on the phone. Well, that's fine. Now, all they had to do was send you authorization just to get that information as to the call that he was on at that time, and nothing more. Again, it's an amazing world, and nobody does the math, but I've been sitting up here doing the math, and it just ain't been adding up, y'all. I got my calculator, and it ain't adding up. All right, end of the video, ladies and gentlemen, but remember, this is all about what this young man did. He did a notice of assignment, and she assigned him her redemption rights. And she did the assignment. Notice what their assignment said. Now, therefore, in consideration of the $10 and other goods and valuable consideration in hand paid to Diane by Chess, Diane does hereby grant, bargain, sell, assign, transfer, set over onto Chess all of Diane's right of redemption from foreclosure. See, they did it simply from foreclosure. We're talking about equitable redemption rights, so we're doing all equitable rights. Okay, now let's give you guys something. Certain mortgage executed by Richard, blah, 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 17th day of March, together with all other rights, titles, interest, Diane in and to the property. Now, hold on, let's get rid of that. Where you at, Diane? Breach. No, sample. That one right here. We're going to add something that wasn't in ours, but it's going to be in yours. Let's see. Where you at? No, we don't want to do that one. No, we want to put it up here, number 2. Hold on. I can't see my mouse. That's why y'all see the mouse running all over the place. Uh-uh. See, we did ours, but this wasn't in ours, so that's what I forgot to add. You want all rights associated, either statutory or otherwise. Now, ours includes this because we say hold said equitable rights and all monies arising in respects to the same or accrued thereon to use the assigned absolutely deems necessary and subject to the terms of such equitable rights and interests. The assigner hereby covenants with the assignee the equitable rights and interests. Hold on one second. Okay, now, again, ours already covers this because we talked about full benefits and powers and all covenants contained in the equitable rights and interests. Well, after the property sells, you have the person still has interest in the property, statutory interest. So it already covers that. See, interest is not just that amount that accumulates afterwards. Interest can also be your interest in the property. If there's any interest, see, you still have the equitable right of redemption. That is an interest you have in the property after the property sells. Whew. All right, ladies and gentlemen, we're going to save this document. It's going to accept a sample assignment of equitable blah, 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 blah. You will take that document, because I got so much more to work on today. You will take that document and you will process that document and you will follow what Mr. Chase did and you will watch the videos on equitable redemption. There's only one person talking about equitable redemption. Okay? Get to know it, get to understand it. But I ain't going to keep talking about this, y'all. Sorry, I got a lot to work on, so we're going to let you guys go. It's 2 o'clock in the afternoon. Have a good day. Have a good life. Have a good night. I'm gone. Have a good bye, folks. Adios, arrivederci, sayonara. Y'all know what I mean. I'm gone.